our guests, the lawyers who will be arguing to the McGeorge campus. And I want all of you who are first-time guests to our law school to know that our students always dress like this. I do have a few housekeeping matters. Today, our lecture hall is quite literally a courtroom, and so we need to act accordingly. There is no automatic in-out access to the lecture hall. Once you leave the building, you will need to go through security again. If you do need to leave the building in between sessions, please plan to do so quietly. The desk space in front of you should be clear since no unnecessary personal items are allowed. Especially no cell phones. The use of cell phones is not permitted during the hearings, and that includes texting, audio or visual recording, or even taking out your phone to check the time. There will be a Q&A session afterwards with the justices that will be held immediately after the arguments are finished. I do want to thank all of you and all of those who are watching online. I especially want to thank what I regard as the best District Court of Appeal in our state, the 3rd District Court of Appeal, and the all-star justices who will be in front of you this morning: Justice Roby, Justice Duarte, Justice Krause, Justice Bulwar-Uri, and Justice Mesiwala. Thank you.
All rise. The Honorable Acting Presiding Justice and Associate Justice of the Court of Appeal for the State of California and for the 3rd Appellate District. Hear ye, hear ye, hear ye. This Court of Appeal is now in session.
Please be seated. Good morning. Welcome to the Court of Appeal. It's our pleasure to be here at McGeorge School of Law. We have 2 cases on the morning calendar. The first case is Brinsmead versus Elk Grove Unified School District, case number 96394. Can we have appearances for the record, please, from the appellant first?
Yes, thank you, Your Honor. John Adams on behalf of appellants, the family of Genevieve Brinsmead.
Thank you very much, Mr. Adams. And for the respondent?
Good morning, Your Honors. Scott Dixler for Elk Grove Unified School District and its officers.
Thank you very much, Mr. Dixler. Mr. Adams, you have 15 minutes. Do you like to reserve some time for rebuttal? And if so, I'll try to keep track for you.
I would, and I've got my watch here too. Thank you, Your Honor. I'd like to reserve 3 minutes, please.
Okay, I will try to double up for you, okay?
Thank you.
You may proceed, sir.
Obviously, with an audience like this, I was expecting a lot of questions, but there were 2 areas that I was hoping to discuss with the court. And there are 2 exceptions to Education Code Section 44808. The first one, the primary argument, is the undertaking to provide transportation. But we also argued in our brief there was a specific assumption of responsibility, and I also wanted to briefly touch on that. As this court's aware, and as I know the audience is aware from the materials, district's position is that it never provided transportation on the day of the accident because Ms. Brinsmead did not board the bus. And certainly this court is aware that the bus was 40 minutes late. There was no notification to Ms. Brinsmead.
Well, that's the issue, is whether you have to actually be on the bus in order to have any potential liability.
Absolutely, and that's district's interpretation. And Your Honor, we think that's an extremely narrow interpretation for several reasons. First, as the court in Eric M. noted, obligations to student aren't just when the wheels on the bus are moving, but rather to provide a reasonably safe system. In fact, this court in Raymond, before Education Code Section 44808 was enacted, also recognized the duty to provide a reasonably safe system.
Can I ask you something about those line of cases and just the canons of statutory interpretation. Usually when we have a rule, which is codified in the education code, which is immunity, then we have exceptions to that rule. Aren't exceptions to the rule supposed to be narrow? So how does that dovetail with your argument that it's too narrow here?
Thank you, Your Honor. I'm not aware of a published case that's interpreted Section 44808 that's made that distinction. I know, and I believe in the cases that I've read that this court has interpreted this section. It hasn't gone down that path. I know opposing counsel has made the argument. The case they cite wasn't a case that involved governmental immunities, wasn't a case that involved Education Code Section 44808, but was really a dissenting opinion that made a general broad brush comment about, well, that's a more narrow clause than a broader clause, and therefore we should interpret it that way. I would think because the Education Code Section 44808 reflects the common law, you would apply the statute as is. You would apply the statute as you would common law beforehand and read it as it is. So I don't think that the exceptions should be interpreted narrowly because they are supposed to reflect common law.
And so in some sense, that supplants the idea of the statute, the canons of statutory interpretation, that exceptions to a rule are supposed to be narrowly construed.
Well, I think in this context, I call it an exception to the rule, but when the legislature enacted the Government Claims Act, it was not only imposing immunities, but it was also in effect imposing statutory liabilities. And certainly when you're dealing with employees of the school district that we have sued, the common law is going to apply to them unless, of course, the immunity statute applies. And even under a narrow interpretation, Your Honor, in today's world, as opposed to 1977 when the statute was enacted, I think transportation includes things like we're arguing, real-time communication or monitoring of buses, communication with students. That's part of the transportation process, or at least, remember, this case isn't a summary judgment case, it was on a demur. And I think it's very important that the parties be able to do that level of discovery as to what this school system considered part of their transportation system. That may ultimately be a question of law for a judge in a summary motion setting. But I could also see where maybe a jury might get involved with that. Would a school district the size of Los Angeles, San Francisco, or San Diego, like we explained in our reply brief, that has these sort of monitoring services, would that be, because they're a big school, something that's expected as opposed to maybe a smaller school? So one of the arguments I really did want to make in the case is that this was decided on a demur. This case was adjudicated much too early. Ultimately, we think it's the jury that should decide the issue, but I can also appreciate if the court's thinking, well, this is really more amenable to a summary judgment motion.
Well, you mentioned demur, and if the issue of proximate cause and all these other elements of a tort, because this is really a tort, those will all have to be fleshed out. If we reverse the decision on demur, you will still have to apply the law as it, proximate cause and various other elements that have to be shown, right?
Yes, Your Honor. And given the gravity of this case, I really do think that this court would be doing a great deal of justice to reverse, and at least let's see what happens at the summary judgment motion stage.
Well, I was going to ask about that as well. Can you hear me all right?
Yes, thank you, Your Honor.
I'm getting it's hard to tell. This is really not, it's not up to us to even talk about, let alone decide liability. It seems to me we're talking about immunity versus lack of immunity based on these two exceptions, right?
Yes.
And your point is that it was thrown out so early. It was even before the judge could take a look at the facts. This is really on the pleadings that we're looking at and whether it's clear that these exceptions apply or they don't.
Yes, Your Honor, and I don't think that it's clear that it applies. Certainly parents have a fair expectation when they're paying for a bus service that Buses should reasonably run on time. We're not asking for perfection, and certainly there are going to be buses that are late. But at least most, if not all, school systems in today's society really should be equipped to timely notify, or at least attempt to notify students and parents, because I think both sides will agree nothing good typically comes out of students having to wait for an extended period of time at a bus stop.
Well, if this case went to trial, whether 40 minutes was an unreasonable time to wait would be litigated. I mean, because that's the
Absolutely,
question.
Your Honor.
How late can a bus be before there is a
Right.
liability?
And this is why we're not opening a Pandora's box of liability, as the district suggests, because for the plaintiffs to recover, there's still a lot of hoops that they need to
You would
go
have to
through.
prove that it was reasonable for her to do whatever she did after 40 minutes.
Yes, absolutely, Your Honor. And then there's certainly issues of comparative fault as well, too. So again, we're not asking for perfection. We're just asking for a fair opportunity to litigate and let the community decide what's a reasonable period of time.
Or even let the judge decide. I mean,
Or a
it could
combination
well,
of both,
it could well
absolutely,
be
Your Honor.
that this
Yes.
is a summary judgment case, but that's
Yes.
not, we're not here on that.
If I were on the other side, I would be thinking about summary judgment, but not demur.
Right, because you did use the word reasonable one more time. And after I asked you the question whether that was really even at issue here, because it seems to me, you know, that the two very narrow things that we're looking at is whether it's absolutely clear that either one of these two exceptions has undertaken to provide transportation, right? And is or should be under the immediate and direct supervision of an employee. I mean, that's really what we're looking at. isn't it?
Yes, and briefly, because I do want to touch on the second exception that I wanted to argue. I think should, as an alternative verb is or adjective, is extremely important, because at least it leaves open the opportunity for a circumstance like ours where someone is not on the bus, but had it not been excessively late, or had she been notified, she would have been on the bus. On the second exception, here's where maybe I can add a little bit to the briefing. Certainly, we argued that district accepted the responsibility to provide stable and reliable transportation. I think that was enough to survive the demur stage, because that's accepted as a fact. But if the other side
And the
makes
question is was a 40-minute late bus reliable transportation?
Yes, and there's even, there's a second component to that, Your Honor, and the component is, under the circumstances, should the school have notified Ms. Brinsmead and her parents? So there were two other allegations that I did not mention, but I appreciate that this court's task is to review the entire complaint. So there are two very important allegations I want this court to be aware of. First, at Appellant's Appendix, page 139, paragraph 47D. The allegation, and I'm going to change around long names to short names. District failed to adequately supervise and instruct students, including Genevieve, concerning bus transportation, bus schedules, and what to do if the bus was late. That opens the door for the next section, and that's at page 142 and 143 at paragraph 58, and this is extremely important. The allegation is, district had a duty to notify Genevieve Shin Brinsmead and her parents whether the bus was delayed, when it would arrive, and what to do under such circumstance. And further, specifically had staff that was responsible for the duty of notifying Genevieve and her parents of such circumstances. So that brings in the issue of assumption of responsibility to notify. And then, of course, the complaint says there was no notification given. At the demur stage, you can't adjudicate that. I think that's extremely important. And with that, I see I have about 3 minutes left.
You actually have 4 minutes.
Oh, okay, well.
Mr. Adams, can I ask you a question
Yes.
with that?
Now
1
you
minute?
don't.
You mentioned, you mentioned a little while back that Genevieve's parents paid for this bus service.
Yes, Your
Do you
Honor.
think it makes any difference that they paid for it?
No, I don't, but I suppose to some extent it adds insult to injury. And in fairness to the district, that payment is under the, I believe, Education or Government Code statute, essentially at cost. But
It was
still,
nominal,
it is,
yeah.
it is a cost, and I think it adds insult to injury to say, you pay for this service, but don't expect it to be reliable.
But you wouldn't draw a distinction between families who couldn't pay
No,
for these
absolutely not.
services and somebody like
No, I think
Genevieve's
that
family who
rules
could?
should be applied the same,
Okay,
Your Honor.
thank you.
And I'll reserve my time. Thank you.
And you have 3 minutes and 20
Thank you.
seconds. Thank you, sir. Mr. Dixler?
Good morning, Your Honors. Section 44808 broadly immunizes school districts, their officers, and employees for injuries that occur off campus, subject to only a few narrow exceptions. One of those narrow exceptions, and the ones the court has spent the most time discussing this morning, is the exception for an undertaking to provide transportation of a student to school. That exception doesn't apply here as a matter of law.
Why not? What if the bus ran into those students standing at the street corner? They're not on the bus yet.
If the bus ran into a student at the street corner, I think that probably would be in connection with the undertaking of transportation.
But they're not on the bus, and your position is you have to be on the bus to have liability.
My position is you have to be engaged in the transportation process. So the bus pulling up to the curb and boarding students is a different scenario.
Why isn't waiting for a bus engaged in the transportation process?
Your Honor, no case has held that. And
Well, that doesn't mean that it can be the law. There's no case that says it isn't.
Well, I'll answer that question, Your Honor, but I want to back up and show why this conversation illustrates why this is properly resolved at the demur stage, because we're talking about pure questions of law. So in terms of the scenario where the bus never arrives, there's no undertaking, and I can explain why. That's true because of the plain language.
Even though they said they were going to have a bus.
They did.
There's a bus scheduled. It's supposed to be there.
There was.
You all agree with that.
Sure, yes.
And
But
it was
when-
40 minutes late.
Yes, the bus was 20 minutes late when the allegation is that the bus was 20 minutes late when Ms. Brinsby texted her friend, and then she waited 20 more minutes for the friend to pick her up. But there was
And
no.
the bus still wasn't there.
That's right.
So the bus was 40 minutes late.
It was. And again, you're right that if this case is remanded, there could be litigation about whether that was a reasonable period or whether her behavior was reasonable, but none of that matters to the issue before this court, which is whether there was an undertaking to provide.
Well, no, because we can't adjudicate it because that was never presented to the court, those issues. The facts relating to those issues were never presented to the court to decide because it was decided on a legal issue that the immunity applied and therefore there was no liability, period.
That's right. And that was appropriate. And the reason why it was appropriate is that the plain language of section 44808 requires an undertaking, even if there were some ambiguity about whether undertaking means actually transporting the student or the mere promise to provide bus transportation even before the bus arrives. That's resolved by the statutory text in cases interpreting it. So under the statutory text, the word specific, once specifically is used
Well,
twice.
there is no case on this particular issue before us.
Well, there's cases applying the undertaking exception. There's not a case about a situation where the bus doesn't arrive and the student then decides to get to school on her own steam and is injured. There's not a case with those exact facts. However, in the prior cases, for example, Eric M. was brought up. Eric M. illustrates why this case was properly dismissed. In Eric M., the student boarded the bus on the way home from school, left the bus, started to go home, and was injured. That was a case where the transportation process had begun. If it were enough, as opposing counsel says, that there were merely a promise to provide transportation, then the Eric M. court wouldn't have conducted that analysis. It would have been enough that there were school buses involved.
Let me ask you this, Mr. Dixler. With any statutory interpretation, we start with the words of the statute, right?
Yes.
And so this statute says has undertaken to provide transportation, right? The legislature could have just as easily have written provide transportation, right? So they have this phrase has undertaken to. If they wanted to start the immunity or the liability at the point of providing transportation, they could have said that, right? So doesn't the fact that the legislature included the phrase has undertaken to provide less immunity for situations like yours?
I don't agree with that, Your Honor, and here's why. I think the phrase undertaken to provide transportation broadens the immunity compared to if the statute just said provides transportation, because provides transportation could mean, well, provided in what sense? Does it mean having a bus system? Does it mean picking up the student? What does it mean? Undertaken to provide transportation implies to me doing something. In other words, the district picks up the student, takes the student to school, and that makes good sense.
I still think that undertaking includes being late. If you're late, that's part of the undertaking. I just don't, I don't understand your argument.
Well,
If the bus is late, that's part of the undertaking.
If I may go back to a point you made and ask a question about that. You said if, in answer to Justice Mezuala's question, you indicated undertaken was added to make it very clear that I guess, am I right, that the effort was actually required? Because it seems to me if it weren't for undertaken, you might even have a better argument, because if just provide transportation, you would be arguing, well, no transportation was provided here. I mean, that may be the issue, but that's an issue for another day. But here the bus didn't come. I mean, that's the problem, right?
Right, and so we have to deal with the statute as it is, and it says undertaken
It
to
says
provide transportation.
Undertaken. So what did undertaken do that helped your position? If it looks to me like you would have a better position without that phrase.
We win under
Not that one.
undertaken to provide transportation because in the context of the statute as a whole, there was no undertaking. A school district undertakes to provide transportation, and I would cite the language in Eric M. that says the process has a beginning, middle, and end. The beginning is when the bus arrives, picks up the student, transports the student to school, drops the student off. And that makes good sense as a matter of public policy compared to reading undertaking very broadly to mean promise to have it come, but it never came. And here's why, if I might.
Okay, and also address the fact that Eric M. wasn't really talking about, I mean, in Eric M. it happened after the bus picked up the Eric M. and he got off. So they had to address that scenario. They weren't really talking broadly about the entire concept, were
Well, they were talking about the facts of that case, that's true,
Okay,
like
so
any
please-
case does.
please go ahead.
Yeah, like any case does. But all of the exceptions, the general rule of section 44808 is that there's liability for on-campus injuries, there's not liability for off-campus injuries. So, and then there's the exceptions. But the exceptions all make sense. There's the exception for field trips, there's the exception for transportation, and then there's a catch-all exception where the district specifically assumes a duty. All of that makes sense when you consider the fact that on a field trip or a school bus, you have an extension of the campus where the district can supervise students, and the district stands in an in loco parentis relationship with students. That is on a school bus too. When students board a school bus, they're entrusted by their parents or guardians into the care of the district. The parents and guardians can't help them when they're on the bus. They're under the supervision of the school. On a field trip, similarly, yes, they're not on school grounds, but they're taken by the school someplace else, and they should be supervised because they're in the in loco parentis relationship. So you can think of the school bus as a rolling campus in that way. When the school bus never comes, the in loco parentis relationship never begins. There's nothing the district could have done to prevent Ms. Brinsmead from making the choice, as was her right to do, to get a ride with her friend.
But let me ask you this, your friend on the other side, Mr. Adams, talks about the school district not having provided her with any information about what to do if a school bus is running late. Is she supposed to stay at the school bus? Is she supposed to, bus stop? Is she supposed to walk home? In that situation where they've told her the bus is going to be coming at a certain time, what else is she supposed to do? And why isn't that an undertaking to provide transportation without any direction of what she's supposed to do when the bus is running 40
So, Your
minutes
Honor,
late?
I want to stress that we're here at the demurrer stage, so the
Correct.
actual facts can get developed later if the case is remanded. But assuming the truth of the allegation that she was never told, that would go to breach of a duty, but it wouldn't go to the question that we're here today to talk about, which is whether there was an undertaking in the first place. And under the statute. So
Well,
that-
whether there was a duty as a result of the interpretation
Right.
of the
Where-
statute. We're talking about it, this is a duty case.
Yes, the section 44808 is interesting because it's an immunity statute, but it's also a duty statute. It explains that there's a general rule of immunity, there's exceptions, and when one of the exceptions applies, there's a duty of reasonable care. So notifications, the adequacy of notifications, how late the bus was, all of that would go to whether there was reasonable care. But we don't have to get there to affirm, because the question is whether there was an undertaking, and there was no undertaking. Also, to satisfy her requirement, the plaintiffs have to show that Ms. Brinsmead was or should have been under the district's supervision. The district had no duty to supervise her at the bus stop, And when she made the decision, which again was her right to do, to travel to school with classmates, the district couldn't have supervised her when she was on the road doing that.
Isn't it a reasonable statement to make that she should have been under the immediate supervision of the school if the bus had gotten there on time? Right, she would have boarded the bus, gotten, and been on the bus.
Presumably that's true, but under the facts of this case, it's a fact of life that buses can be late. Everybody would agree with that. No district can guarantee perfection in bus transportation, just like no other transportation system could guarantee that. It's not reasonable.
Well, but that goes to the question of reasonableness. If there is a duty, then one of the questions under the duty is, which I talked about with council, how late is late? I mean, how much slack do they get?
Right, and
what is a reasonable student supposed to do standing waiting for a school bus? How much should a reasonable, however old student is, how long should you have to wait before you do something different than waiting?
The legal question, Your Honor, here though, is whether there's a duty. One of the factors, if this
Whether
court...
it extends to somebody waiting for a bus, yes.
Right, that's the question.
That's
And whether
the
it was someone
single
waiting
issue.
for the bus, well, yes, with the caveat that if there's no undertaking, there's no duty. So it's a question of law whether, the question of law posed by this case, it requires analysis as a matter of law of the public policy consequences and the risks and benefits of imposing a duty on school districts when buses are late.
When they're
Now,
not on the
council's-
bus.
Council says,
Your position is, if they're on the bus, there's a duty. If they're not on the bus, there isn't.
not quite, Your Honor, and that's actually an
Pretty
important...
close.
No, I don't think so, and let me explain why. In a case like Eric M., or in a case like Farley, where the student boarded the bus and then was released from the bus in a negligent way, was released from the bus too soon, was released from the bus in the wrong spot, that there was an undertaking, and then you had on-the-bus negligence that led to an off-the-bus injury. That there's no immunity, and that also goes back to the Hoyam case, the California Supreme Court's Hoyam case, where you had an off-campus injury that was caused by on-campus negligence. That makes perfect sense for the reasons we were talking about. The school district is in an in loco parentis relationship with the student when the student is on campus, on the bus, et cetera, has a duty of reasonable care. But when a student never boards the bus, there's no duty to that student because the district can't do anything. When Ms. Brinsmead made the decision to ride with a friend, I'm not criticizing the decision at this stage. We're at the demur stage. She made that decision. She had a right to do it. But the district had nothing to do with the wrong way driver swerving into the other lane and...
No, well, that goes to the issue of proximate cause. This is a Paul's graph issue or one of those tort issues down the road. The question is whether, if you're still waiting for the bus, the undertaking includes that time when you're waiting for the bus.
Can you state, and I know you have very little time left, Mr. Dixon, can you state the bright line rule that you want us to adopt that includes has undertaken to provide transportation?
Yes, the bright line rule is that there is immunity under section 44808 until the bus arrives. Once the bus arrives and the boarding process begins, there's not immunity if there's negligence of the bus driver, for example, in the boarding process.
So there's two things. The bus has to have arrived and the students have to be boarding the bus.
Yes, I mean, there could be interesting close cases about where the student's at the back of the boarding line and something happens. That's not our case here. That might be a trickier case. But where the bus hasn't arrived yet and the student is injured while attempting to get to campus on her own, there is immunity because the statute says there is and because the reasons for immunity are satisfied. The district had nothing to do with it. The district is immune when there's the negligence of another party not on campus, there's an off-campus injury that the district wasn't involved in. That's quite a different scenario from what some of the cases talk about, like in Eric M. or Farley, where you had a bus pick up a student and then negligently let the student go in a way that causes an injury. Or one of the cases cited in the briefs where the student made a toy cannon at school, took it home and was injured and there's liability. That was on-campus negligence leading to an off-campus injury. Here we don't have the equivalent of on-campus negligence because the bus never came. You have purely off-campus negligence resulting in an injury, and that would be the negligence of the wrong-way driver and the negligence of the other students.
Thank you.
So this court should affirm. Thanks.
Thank you very much, sir. Mr. Adams, you have 3 minutes and 38 seconds.
Thank you, Your Honor, and I'll probably take less. There are just a couple of points I wanted to make in response. Certainly, no California case has delineated clearly when transportation begins and when it ends. And as the panel noted in Eric M., it really just stayed within the confines of its facts, which is why we had to go to out-of-state authority. And I won't get into that authority, but I think it at least gives this court some good insight as to how other jurisdictions expect school districts to act in at least similar circumstances. Public policy reflects societal expectations. And, you know, given the similarity in relationships between school districts and their students and parents and their children, no parent is going to be able to abandon their child. They're going to be held liable for that. Well, nor should a school district effectively abandon children at a bus stop without at least giving some indication or attempt to communicate with them and their parents. And again, at the demur stage, this can't be flushed out.
A point raised by counsel, to summarize, is that this would be, if we go your way on this case, and you can correct me if I'm wrong, I haven't seen another case that is completely about what the school did not do. It always has something to do with something the school did. In other words, the examples just given were, in Eric M., the bus had come, the bus negligently released the boy. In the bomb case, the school had been present and let him build the bomb and take it home,
Right.
the explosive. In the other bus cases that we've read, the school was doing something. And here, all the arguments are what the school did not do. The bus never came. The school didn't warn. The school didn't do all these things. What's your best argument for why that doesn't matter, I guess?
A couple, because we haven't had a case like this. This is the first time under our fact pattern that I'm aware of courts had to deal with the issue. And again, it's on the demur stage, and I would respectfully disagree to some extent, Your Honor, about the school didn't do anything. The school undertook the obligation to provide transportation, and once it did so, it had an obligation to provide a reasonable transportation.
I mean, a bus
system.
did come, it just came late.
I don't know, Your
Well, I mean,
Honor,
let's
and that-
assume a bus did come. I mean, nobody said that they just
Well,
completely abandoned.
that's true, and those are facts that'll have to be fleshed out at
Right.
summary judgment stage. When did the bus arrive? And again,
Is that relevant? Why is that relevant?
I don't think it's relevant.
To your argument.
To my argument.
And when I say don't do anything, I don't mean to minimize what happened. I hope you understand what I'm
I
saying.
do.
I mean an affirmative action taken, like picking up the student and then doing something wrong, letting the student build and then doing something wrong. I'm talking about all these things that the school, more like an act of omission, I guess, is what we usually call it.
Right, and that's why I did make the alternative argument that if this does not qualify as transportation, given the allegations in the complaint, they undertook a responsibility, assumed a responsibility.
Thank you very much, sir. Your time has expired,
Thank you, I appreciate the court's time.
and the court will be in recess for 10 minutes.
come to order. Court of Appeals now in session.
All right, good morning again. Can everyone hear me all right? Yes? All right, in the back? Okay. Good morning again. We are back for the second argument, and this case is the case of John Valter versus Mammoth Mountain Ski Area LLC 96036. Counsel, please state your appearances. I see you at podium. Are you the appellant, counsel for the appellant?
Yes, Your Honor.
All right.
Christopher Dolan on behalf of the appellant.
All right, and respondents, counsel?
Good morning, Paul Kellyan from Dwayne Morris on behalf of the respondent and the appellant.
All right, good morning to you both. Let me just set my timer here. I don't know how to work this one up here. And we will get started. All right, whenever you're ready.
Thank you, Justice. I'd like to reserve 3 minutes for rebuttal, please.
Absolutely, and you'll also get a 5-minute warning.
Thank you. So the issues that need to be addressed here are some are procedural and some are more law-related. The first procedural issue is that the judge made determinations of fact as to who he believed, Mr. Valter, the degree at which the snowmobile was crossing, the fact that Peters did not make a turning movement into Valter's line, and that Peters' operation was in compliance with safety procedures. These were findings by the court during a summary judgment motion. That's not applicable or appropriate summary judgment. All the inferences are to be given in favor of my client and our pleadings, but the judge did exactly the opposite. And in that regard, the main thing is the judge said the snowmobile was stopped. Everything flows out of the snowmobile being stopped, but there's direct contradictory testimony that was given by a Mr. Smith who had the bird's eye view. And Mr. Smith indeed drew a diagram and wrote that he was traveling slowly. Mr. Peters told the officer he was proceeding at 5 miles per hour. The court said that the snowmobile was plainly visible, yet the court failed to understand or recognize that there was a dynamic situation with the snowmobile coming uphill and with the skier going downhill. The court had it appear as if that object was there, readily and available and visible, much like the court did, let's say, in the Connolly case, which had to do with the snowmaker, or in the Sousa case that had to do with the pole for the chairlift. So on the procedural basis, that is one of the issues. Procedurally, the court struck the expert depositions that included testimony by industry safety standards as to what those standards were.
Did you challenge the evidentiary rulings on appeal?
Your Honor, I believe we did not in terms of the appellate brief itself, but insofar as the
Well,
court
then
is
you
reviewing this.
can't, you can't argue that the court was wrong to strike those expert declarations then.
Thank you, Your Honor.
And you have no expert supporting your position on the standard of care. So let's assume that the snowmobile was moving. And assume, because I think it was undisputed, that the dynamics were, as you described, with the two ski runs. Where is there gross negligence from Mammoth on this?
Your Honor, the Rosencrantz case indicates that a violation from a safety standard itself can constitute gross negligence. In this case, the safety standard was set forth in the route guide, which wasn't a guide, it was a route safety manual. And indeed, it was indicated in the respondent's brief itself on page 20 that that was set to industry safety standards. So the violation of an industry safety standard itself can constitute gross negligence. Moreover, Your Honor, there was no thought or plan into the design of this snowmobile route. Mr. Erb testified that they had never sat down, analyzed it, formally studied it, and interestingly enough, that was 30-some years ago. But as soon as this incident happened, the subsequent year, and it was not a remedial measure according to Erb, they sat down and they analyzed safety as it related to snowmobile-skier interaction, and they moved the snowmobile route over to Mambo and had a setup of a corridor with ropes and signs at the very top saying snowmobiles coming. So their own shift itself to the industry safety standard can also show gross negligence.
But wasn't the shift for an alternative route not for safety reasons? Wasn't it for another reason?
No, Your Honor, it was not. There was an indication directly from Mr. Erb that it was based upon a mitigation effort. And that it was not just for shortness or brevity, but it was a mitigation effort designed to promote safety. I'd like to address, if I may, the assumption of the risk matter, if there are no other questions about the express
Well,
waiver.
I have a question about your last comment about promoting safety. Even assuming that it was to promote safety, is that evidence that the prior condition was outside the standard of care? And isn't that is what required? The general standard, safety standard is required?
Well, Your Honor, one of the main things is they never considered the safety standards. That in itself is gross negligence for not considering whether there would be an interaction problem at this location.
When you say safety standards, what precisely are you talking about? Because I think we may be talking about two different things.
Well, Mammoth is the largest ski resort in California. They indicated that in their papers at page 20 that they abided by industry safety standards when they established the snowmobile routes. So by
Right.
their own statements, that is it. Insofar as they are the industry leader, their own decisions as to where to place these routes as far as safety is concerned itself can be evidence that a trier of fact, when inferred, could find that indeed the deviation from that was gross negligence. The other issue of gross negligence is Peter's extreme departure from the route.
But is there, I'm still confused as to your earlier point. Is there evidence in the record that the state of the runs at the time of the accident deviated from the safety standards? And if so, what is that evidence?
The evidence, Your Honor, is the subsequent laying out of the route, which is the industry safety standard as followed by Mammoth. It is not a subsequent remedial measure. When they sat down and they thought of mitigation efforts and how to promote safety, they moved the route.
How is making something safer necessarily proof that the previous version did not conform to industry standards?
There can be an inference taken from that, Your Honor, that if Mammoth is the one...
Quite an inference.
Pardon me?
It's quite an inference without any evidence.
Well, the evidence was actually in the declarations that got stricken, but we did have an industry safety
Then it's not
standard.
evidence.
Pardon me, Your Honor?
Then it's not evidence.
Understood.
Okay.
May I move, please, to the assumption
Yes.
of the risk? So insofar as the assumption of the risk is stated, what we really need to figure out is whether the conduct of a snowmobile operating on a ski slope is something that's inherent in the sport of skiing, such that finding that it was not would in any way chill the vigorous participation in the sport. Mr. Erb, who is their safety director, when asked directly whether snowmobiles were involved in the sport of skiing, he said no, they have nothing to do with the sport of skiing.
Well, let me
Mr.
ask you,
Dolan, I'm sorry, go ahead, Justice Messawala.
don't the undisputed facts show that the ski resort use of snowmobiles improve the safety of the ski resort?
No, in no way, shape, or form, because in this case, Your Honor, it has to be looked at the activity that is being undertaken. It was not a ski patrol. It was not in any way an emergency repair. It was a person traveling to their job site. Therefore, it's not intrinsic or inherent, it's extrinsic. And Your Honor, there are cases on point. For example, Knight v. Jewett, if we look at that, the seminal case. In an interesting statement that is not in a ski case, what the court said that because getting injured while skiing may be inherent risk, they'd still have to maintain their tow ropes so that someone wouldn't be injured. That's an operational component of the skiing. The same is true with the snowmobile, Your Honor. It is not something inherent in skiing, which involves falling down, which means maybe going over a jump. And the other case that addressed this, Your Honor, was the Solis case that has been cited as well, where interestingly enough, the court, it was Solis versus Kirkwood, and when the court was dealing with the issue of whether it was inherent or not, they said that riding dressage, barrel racing has barrels involved in it. That's a risk. But a horse on a racetrack would not expect a barrel to be in the location where it was.
Counsel, aren't there signs at the top of each of the lifts indicating that snowmobiles may be encountered at any time. Is that not correct?
That's not correct, Your Honor, nor was there evidence that was submitted that was admissible because Mr. Erb, who validated those photos, didn't take them, didn't know that where they were taken, and they didn't say that they were at the top of the lift where my client came off.
Am I incorrect that the record indicates that the trail maps also note that snowmobiles may be encountered at any time?
It is written on a portion of the trail map, yes.
Am I incorrect that the liability waivers that Mr. Valter or any season pass holder would have to sign indicate that snowmobiles may be present and that there is a risk of collision with them? Is that correct?
Yes, Your Honor, it is correct. But the difference is they increased the risk by the manner in which they operated this in an uphill manner around a blind corner where there were trees, and Mr. Peters departed from their own safety standards. So if we're talking about, is there a safety standard? Yes, it's the one they promulgated. And it said he was supposed to be to the left side of St. Moritz, to cross and then go up the left side or skier's right of Stump Alley. But what for example, Mr. Smith said, and he drew the drawing, and that's drawing number, in Appendix 4-811, he drew him, he said he came up the middle of St. Moritz, and that then he was going 5 miles per hour, and therefore he was not following the route. The photographs themselves that are shown to the court in 4-950 show the snowmobile oriented such that it's going up the right side or the west side. And indeed, Mr. Peters testified to the police, or told the police officer, he was going right and up the west side, Your Honor. And that is a violation of their safety policies. So they increased the risk above that would normally be associated with the sport of skiing. Skiing does not involve snowmobiles or dodging snowmobiles. In Wilhelm Nicholas, there was
Wait, can I stop you there? Your client, though, acknowledges the presence of snowmobiles at this resort. Your client is an expert skier. There's evidence in the record, at least as I read it, that the snowmobiles were present to try to improve the safety of Mammoth. So how are we to say in the primary assumption of risk that a visible snowmobile is not an inherent risk in the sport of ski?
Thank you, Your Honor. First of all, there was no reference as it relates to this snowmobile being involved in anything to do with safety. It was transporting Mr. Peters to his workplace, nothing to do with safety. And one needs to look at the particular use of the vehicle when determining whether or not it would be something that would advance or would be changing the inherent nature of the sport. So the question was, is there anything in there about safety? The answer is no, Your Honor.
I think your client's words were that snowmobiles are very useful and efficient in the operation of a ski resort. Did I get that quote right?
Absolutely, and the key is the operation of a ski resort, not in the sport of skiing. Because, Your Honor, you could have many things, like electricity are as good in the operation of a ski resort. But if an electric wire is touching a pole that someone touches and they're electrocuted, then by extension, that would be something that would be in the assumption of risk.
Mr. Dolan, you asked for a reminder and you're under 2.5 minutes. Did you want to reserve or did you want to keep going?
Yes, Your Honor, just for a half a minute, please.
Sure. It's your time. You use it as you see fit.
Thank you. And finally, in Solis, the court said that an ordinary skier would not expect to encounter an object in the area which was the jumps. They set up jumps, which are inherent and are in the waiver. But the court said that a skier would not be someone that would be, ordinary skier would not expect them to be encountered there. And finally, Your Honor, my client indicated he'd never seen a snowmobile at this area. I'd like to reserve any extra time.
All right, thank you. You're down to about 1 minute and 47 seconds. I'll give you 2 minutes when you
Thank
come
you.
back. All right. And let me reset. Give me just a minute, sir, and then we will get going. All right, whenever you're ready.
Good morning, may it please the court, Paul Killian. There are two bases for the summary judgment. There's express and there's primary assumption of risk. On the primary assumption of risk, plaintiff's injuries here were caused by risks that are very much inherent in the sport of skiing. One of the most important inherent risks is to not hit obstacles on the slope below. And that's what happened here. Mammoth has no duty to protect skiers from inherent risks in the sport. And Mammoth also has no duty to minimize or decrease those risks inherent in the sport. My friend argues about, said that snowmobiles are not part of skiing. Well, in one sense, I suppose that's true. I mean, certainly you just strap on your skis with boots and off you go. But he wasn't skiing in the woods. He was skiing at a resort. And running a resort requires snowmobiles. It's absolutely essential. And that's why
If I
they're an
remember
inherent-
correctly, if I may, if I remember correctly, that was an undisputed fact. Am I wrong about that?
That is correct.
Okay.
That
'cause
is
it-
correct. It's also undisputed here that the plaintiff hit the snowmobile, not vice versa. And that's undisputed. In particular, I'll point the court to their number one additional statement of fact they put in their opposition. That's at page 1588 of the record. They also, in that same undisputed fact, said that the snowmobile was stopped. That's what they pled in their complaint in 2017. That's what they answered in a verified interrogatory response in 2018. And then they included it in the summary judgment proceedings in 2021 in their number one leadoff additional separate statement of fact, which Mammoth, of course, didn't dispute. In that same undisputed statement of fact, it also says that Mr. Valters hit the snowmobile. This isn't a situation where the snowmobile ran into a skier.
Is it dispositive whether it was stopped or not? I understand you're saying that was an undisputed fact.
I don't think it is, because it's still an obstacle and it was slow. And the trial court made that observation. The trial court said it doesn't really matter whether or not it had come to a complete stop.
Mr. Clay, and if I can ask you, I think what your friend on the other side is arguing is that while obstacles can be inherent in the sport of skiing, a snowmobile isn't inherent as an obstacle in the sport of skiing. So how would you factor in the use of snowmobiles as not being inherent, let's say as a boulder or something like that?
I missed the last part. At a boulder?
Such as a boulder, right?
Oh,
So
such as a boulder.
if Mr. Walter had hit a boulder, maybe we wouldn't be here today, but what he hit was a snowmobile. And I think your friend on the other side's point is when you go skiing, it isn't inherent. You don't assume the risk of, you assume the risk that maybe you're going to collide with a boulder, but you don't assume the risk that you're going to collide with a snowmobile.
Well, I think it is inherent. It is inherent when you go skiing at a resort. The problem obviously is if a skier wants to go skiing through the woods, there won't be any snowmobiles around, but there also isn't going to be a lift to take him back to the top of the run, and there isn't going to be a ski patrol to respond if he falls and breaks his leg, which ironically, of course, the ski patrol arrived to assist Mr. Valter on snowmobiles here. The other thing that's very important about the facts here, Mr. Valters, it's undisputed, he did not see the snowmobile. He wasn't paying attention. He would have hit anything there, any object, any person. He would have hit a snowmobile responding to a fallen skier. He would have hit a fallen skier at that same location.
What do we do with Mr. Valter's argument that Mr. Peters, the one who was driving the snowmobile, had failed to follow, I think the language was the preferred path, that the failure to go along to utilize the preferred path indicates gross negligence?
Well, first off, I would take issue with counsel's argument that there's evidence in the record to support that, because there really isn't. There's not a single witness said that Mr. Peters was not on the route. And many of them, all that were asked, said that he was. The photos show that, and this was very persuasive to Judge Magid. When he looked at the photos, he said they speak 1,000 words. The accident happened on Stump Alley, on the route. If you look at the route map, which is, we put into our brief, it clearly shows that the accident happened right as the number 2 chair, Stump Alley Express, crossed over the path. Right at that point, that's right on the route. The other thing, moving on now to Express, I mean, Mr. Valters signed a release. It's the same release this court upheld in Wellide Michulas. And negligence is gone. And a lot of these arguments that we're hearing are arguments about negligence. So what's left is an effort to try to show gross negligence. And the plaintiff's efforts fail for some really basic reasons. In order to, the test for gross negligence in California is lack of any care or an extreme departure from ordinary standard of care. And there's just no showing of that here. There's no showing because Mammoth had warnings at the top of the runs, in the trail map, in the release. It's undisputed that Mammoth had a safety policy in place for snowmobiles, that they trained the operators, and that there was a route manual. And
I'm sorry, that there was a what?
there was a route manual.
A route manual?
Yes.
Mr. Clan, can I ask you this? If there was evidence that your client, Mammoth, could have done more to make it safer, would you say that was gross negligence? Because one of the things your friend on the other side has in his briefs is that Mammoth should have also provided maps of the snowmobile routes. What do you make of that?
That wouldn't have changed anything. The tests over and over again in the gross negligence cases are situations where there was just the defendant didn't follow safety standards at all. And that's what we have here, that they did follow. They had safety standards. They followed them. If there's a small deviation in the route, and I don't think there is anything in the record that indicates that here, but if there were, that would simply be a matter of negligence, which of course has been released, not gross negligence.
So your argument essentially is, at most, this is a negligence case. Mr. Walter signed a release of negligence, and negligence isn't actionable in this context.
Exactly.
Okay.
Exactly. Mr. Peters also was on the approved route again. He was also exercising care. The route manual says stay on the climber's left going up St. Moritz, and Mr. Peters did that. The route manual says cross Stump Alley to skier's right, climber's left, and that's what Mr. Peters did. And the manual says the operators have to give the right of way to skiers coming down the slope, and that's exactly what Mr. Peters did. He stopped, and he was going to let Mr. Valter pass, and then he would go across Stump Alley, except Mr. Valters hit the snowmobile.
And you're saying the evidence that he was stopped is undisputed?
It is undisputed. It's undisputed because it's coming right out of their own verified interrogatory responses, their separate statements.
Because the first claim was brought up, I think, on oral argument, was that there were witnesses that indicated there was no stop.
There is the one statement by Mark Smith that he says they were slowing to a stop.
Okay. as opposed to at a full stop at the time of the accident.
Yes, that's the only thing, and it really doesn't matter. If they're going slow, it's an obstacle, and Mr. Walters hit it.
So your argument is that that's not dispositive, even assuming it was moving. It's the yielding, the giving up the right of way that makes the difference, and Peters was doing that.
And he was doing that.
And to the extent that perhaps, don't let me put words in your mouth, but tell me if you agree, to the extent that even perhaps he was a little bit behind the standard of care in that regard, that would at best be ordinary negligence.
Yes. We ask that the judgment be affirmed.
All right, thank you very much. Let me reset the timer for you, sir. And you have 2 minutes left for your rebuttal, and whenever you're ready.
Thank you. To address some of the issues raised by counsel, he leaves out a very important fact, which is in our brief. The safety standard that is in line with industry safety standard is don't cross the mouth of St. Moritz. The photographs show you he was crossing the mouth of St. Moritz. There's no doubt that he violated that important safety standard and put his snowmobile directly in the path of travel. There is a photograph that was marked during the deposition of Mr. Bulkley, who was the PMK, as it related to routes and safety. And Mr. Bulkley at volume 3, 954, drew in the area in which my client was traveling and drew in a bracket that showed where skiers would go. And that bracket is on right around that snowmobile. Mr. Bulkley said he did that all the time too. He skied in that area. The safety rule was you don't put the snowmobile in front of the traffic by crossing the mouth.
So, Mr. Dolan, is it fair to say that your argument that gets you out of the realm of just negligence to recklessness is that here there was a violation of the safety standard, and what I heard you say when you were up here the first time is your client had never seen a snowmobile in this area? So
no, the reason why it gets around for the assumption of the risk is they increased the risk by introducing a snowmobile. They increased the risk and they violated the safety standards by not going up the left side of St. Moritz, and then by going across the mouth in violation of the safety standards, he was trained to go up the right side or west side of Stump Alley in direct contradiction to what the safety standards are. The safety standards are there to protect this from happening. He made a decision to do it. It wasn't accidental. My friend stated that it was almost stopped. Well, that creates a tribal issue of fact as to whether it was stopped or not. The judge made a decision it was stopped. The judge made a decision it was plainly visible. But Mr. Walter testified as he's coming down that hill and the snowmobile is coming up the hill, it is not visible.
All right,
I believe that's my time.
You are out of time. Thank you very much. Thank you to both parties for their arguments. The matter's under submission. The court will be in recess until Monday morning at 9:30. And I'm getting a nod from the bailiff on that. And we will be back shortly just to continue our outreach program. Thank you.
Good morning. Good morning. Hello. The court will be back just momentarily.